We will talk now about aggravated assault. All of the elements of assault must be available and must be proven with the addition of a couple of extra elements to raise assault to the level of aggravated assault. There must be serious bodily injury, additionally the use and or the use of a deadly weapon in this particular assault. Now, what's interesting about the allegation of aggravated assault is that an essential element of aggravated assault is the fear that is subjective in the person that is being assaulted. That fear is a necessary element of aggravated assault. What happens when an individual has a gun in his or her pocket? The person that is being threatened is not being threatened with the use of the gun. As a matter of fact, the individual does not see or recognize that the individual is armed that is conducting the threat against that particular individual. And of course, this has to be absent bodily injury. If bodily injury takes place, even though the individual doesn't or is not aware of the presence of a deadly weapon, then we still have an aggravated assault if the conditions of bodily injury, as will be described in a moment, are present. An aggravated assault can occur in a number of different ways. The code specifies that an aggravated assault can occur against an individual who is a public servant and is conducting that his service in the line of his duty. If that assault takes place, which would otherwise be a simple assault, that would be raised to a aggravated assault, and in fact, it gives rise to a first-degree felony. Without that particular condition and the conditions that will be discussed momentarily, we still have a second-degree felony if the elements of serious bodily injury or use of a deadly weapon are present. Secondly, an assault, for instance, against a public servant in retaliation for something that public servant has done. A peace officer who has made an arrest, a threat against a member of that officer's family can give rise to an aggravated assault, putting it on the level of a first-degree felony, punishable by 5 to 99 years and or life in the penitentiary as a first-degree felony. Retaliation against a person who happens to turn a defendant in for an offense that person has done, or perhaps testified as a witness in a case, or a juror, or a grand juror in a particular case. If a threat is made against either of those, any of those individuals, then we have an allegation of aggravated assault. You can't, for instance, have an individual testify against you, and the next thing you know, that individual is being threatened by the individual against whom that person was testifying. A personal example, I think, would be appropriate to insert at this moment. Years ago, I was representing an individual who was charged with assaulting his wife on the front porch of his home, and the next door neighbor witnessed the assault, and the next door neighbor took the stand and was in the middle of testifying about what was going on. My client was seated directly behind me, and I was facing the witness during cross-examination. I see a juror motion to the bailiff, and the judge stops the proceedings. The bailiff goes to the juror. The bailiff then goes to the judge. The judge excuses the jury. Apparently, unbeknownst to me, during the testimony of the next-door neighbor, my client was physically, with his finger, cutting figuratively the throat of the witness. You're a dead man. Obviously, he ended up being charged. What turned out to be an assault case ended up with an additional allegation of an aggravated assault. Public servant can be a grand juror, can be a police officer, of course, in the official line of duty, can even be a lawyer, can be a security officer, can be a notary public. Anyone can fit into the role of a public servant if the definition fits as far as his line of work is concerned. Deadly weapon. A firearm per se is considered a deadly weapon. A knife, on the other hand, can be considered a deadly weapon if the intent to use that particular knife, that particular item, was to cause serious bodily injury to the individual, or to threaten the individual with fear that serious bodily injury would take place. A deadly weapon could be water. Any item that is capable of rendering death or serious bodily injury, to include physical disfigurement. Any item that has this capacity and is used with the intent to create that particular atmosphere and in fact hurt that individual can be considered to be a deadly weapon. I've had situations where water can be a deadly weapon. A man's hand can be a deadly weapon. Obviously a 2x4, a sharpened pencil that goes for the face. It also is interesting that if I'm in an automobile, and in this particular example is most pertinent in today's climate, and I drive by a house and I don't know if it's occupied or not, but I pull a gun and I randomly and recklessly fire that firearm into that house, and it causes, without my knowledge, serious bodily injury to an inhabitant. That is a first-degree felony, and we often hear of drive-by shootings, first-degree felonies, and again, those felonies are punishable if proven beyond a reasonable doubt by 5 to 99 and/or life in the penitentiary. If a deadly weapon is alleged, then we have the ability of the court to make a determination that if an individual's sentence, let's say, is 30 years for a first-degree felony, because of a deadly weapon finding, that individual will not come up for consideration for parole until 1/2 the calendar period has been served by the person who is incarcerated. So just because we have an aggravated assault as opposed to a murder or a capital murder doesn't make life any easier for the defense lawyer, and particularly for the defendant facing the possibilities that the law carries with it.